Right, we're joined by Director and Attorney at Dubazana Attorneys now, Nthabiseng Dubazana. Thank you for being with us. So let's look at terrorism. That has so many connotations for so many people. Can we start by agreeing that this is a very serious, unusual charge, and tell us what the state would have to prove here?
Yes, indeed, it is a serious charge. Like you said, the state would have to prove intent on behalf of the accused, which is Zandile at this stage, that he had the intention to go against the law and basically perform acts of terrorism, which vary from not adhering to what the law says, which goes up to also including vandalism of national key points and all of those things with the intention to cause or commotion or trauma within the nation itself. That is basically the gist of what it would mean when we're dealing with terrorism, what the state would have to prove. The intention and the unlawfulness and the act itself would fall within the elements of the crime that the state would have to prove.
So it's not just about theft or arson or something for personal gain, but it doesn't go as far as trying to bring down the state, which would be treason. Is that correct?
It can get up to that if the state can try and push it to that extent. Remember how the Terrorism Act was formulated in 1967. It was pertaining to such acts that you're trying to bring down the state because we're still in the apartheid era. So it was an act that was brought forward in order to curb the oppressed at the time from performing certain acts that will then bring down the state that was currently at this stage in control of government. So now that is, if the state wants to take it to that extent, they can try. I don't know how they will succeed. But in this stage, I don't see how the state can take it to that extent. It will be just that he had the intention to cause, to go against the existing laws in that he tried to, or attempt, or he actually rather caused arson to the building itself.
What sort of sentence does he face if convicted on a terrorism charge?
It varies. The sentence can go between 10 to 25 years. It depends on the presiding officer on which way he would go. And it also depends on his SAP 69s, which is basically his previous convictions. So if he has previous convictions that are similar to the one that he's currently facing, then it increases his chances of getting a higher sentence. But of course, this will be determined as the matter goes on. However, looking at where we are at with the matter, I don't see that we will probably get to that stage if the mental observation part of this matter takes a different turn come the 11th of February.
So obviously that's what everybody's watching now, and the state brought up a diagnosis of schizophrenia and now wants him mentally observed. So that would mean he may land up being committed to an institution rather than being sentenced to court, even if he did this, which he has pleaded not guilty to.
Correct. So we are looking at Section 77 to Section 79 of the Criminal Procedure Act, whereby we are looking at the mental capacity of an accused person. So I would have assumed that when the schizophrenia report was brought to court, it would come with a doctor's report to say whether or not he has criminal capacity, in that he understands what had happened, if indeed he understands his actions and the consequences thereof of those actions. However, it seems that it just came that he has schizophrenia, but it doesn't have a medical report that accompanies it. Hence, we are at the point whereby it is remanded for 30 days in order for him to be observed. So once the observation has been done, and then there's a doctor's report that says indeed he is not capable, he doesn't have criminal capacity at the end of the day, therefore he cannot be charged with all these charges that he's currently facing, and then he'll be committed to a mental institution. Should he then, be balanced out and then his mental state is okay, he cannot be held liable for the acts that he committed whilst he was under that medical state that rendered him criminally incapacitated.
All right, the stakes are high here, a lot of interest. There is another terror case that raises a whole lot of questions in October 2016. I don't know if you remember the case of the twins, Tony Lee and Tulsi. They were arrested on terror charges. 5 years later, they are still awaiting trial, which is a very long time. Because of the serious nature, is that allowed to happen? Any comments on something like that?
There could be various reasons why the matter is taking so long to be on the trial roll. It could be that the investigations have hit a stop in that they're not getting sufficient evidence. In such cases, I think the kinds of evidence that is required is not only limited to the witness observations and CCTV footage, etc. There's probably forensic evidence, which I think in our country, we do not have the capacity or the capability to deal with that kind of forensic evidence, as it is with our normal cases, our day-to-day, drunk driving and all of those things. There's such a huge backlog in our forensic departments that we cannot get the answer that we seek sooner than 9 months. So as it is, I think that is probably the reason that have halted this matter. I would say that if it keeps, I'm not sure if it's appearing in court currently and it keeps getting postponed. However, if it's not appearing, it would have been that the attorneys for the accused had requested that the matter be struck off the roll due to lack of evidence and, put in a 342A application with the court.
Yeah, in the meantime, though, they have been denied bail. Could this land up being a long trial? I guess it depends what happens with the observation for the next few weeks. And there's talk of Mafe's lawyer challenging the entire Terrorism Act.
Yes.
What does that encompass and what does that legal challenge look like to you?
Yes, this is a very old act, like I said. It still has very many connotations of the apartheid era. So it hasn't been amended because it hasn't really been used, or it hasn't been really been used in the new democracy. Very few cases have dealt with it and hasn't been challenged to that effect. So I would think that the reasoning for challenging the entire act is that it was placed in an era where it was meant to oppress a certain group of people, versus it being deliberate in that it should counter acts of terrorism instead. So I think that is the angle that the attorneys will be trying to attack the Terrorism Act. And pertaining to the length of the case, because it's a high-profile case, maybe the state hospitals will be in a position to rush the process. But usually, just to get mental observation, a date for you to be observed for those 30 days, we are looking at 12 months or more before you can get to that stage. But we'll see how this matter proceeds as we go forward.
All right. Well, thank you for laying out some of the facts for us. That was Nthabiseng Dubazana, Director at Dubazana Attorneys.